Hello guys, this is Olayeni, Dear Kolola Daniels, and welcome to another episode of Dear Ko Talks Law. On this particular episode, we are talking about one of the rules in relation to consideration, and that rule is the fact that moral obligation will not amount to a valid consideration. In my last sets of classes, I have defined what consideration is according to the case of Korea and Misa as well as Nigerian cases. And also, I have told you the different type of consideration that we have, and they are the executed consideration and the executory consideration. If you have not watched any of these lectures, please make sure that you click the description box below. I have kept a link to these two lectures in the description box. It's going to be very pertinent and useful for you to watch those lectures first before you proceed with this. And also, if this is your first time of coming to my channel, please make sure that you click the subscribe button as well as the notification bell, so that anytime I release a video which is going to be of interest to you, you'll be one of the first set of people to watch that video. And also make sure that you follow me on LinkedIn if you are a member of LinkedIn. And with that, it's time for us to move straight to our lecture, whether or not moral obligation would amount to a valid consideration. But before we go to the lecture, do not forget that in my last class I told you that where there is to be a contract between A and B, something must move from A to B and something must move from B to A for it to be a contract. Although there might have been offer moving from A to B and there might have been acceptance moving from B to A, but still offer and acceptance alone doesn't make a contract binding. It is just the first two elements that you must have. Don't forget that there should be four elements. There should be offer, there should be acceptance, there should be consideration, and lastly, there should be an intention to enter legal relations. In the absence of any of these four elements, then there is likely not to be a valid contract. For example, I gave an example in the last class where I said that A is selling an iPhone to B and B is buying the iPhone for 500,000 naira. That's 500k. Now you can see that there is something moving from A to B and there is something moving from B to A, and also there is offer, there is acceptance. Then this is likely to be a valid consideration provided that there was an intention to enter legal relations. But now, what about moral obligation? Would moral obligation be a valid consideration to enforce a contract in a court of law? That is the question that we'll be asking and ultimately answering in this particular class. Let us go straight to my lecture. Now, a moral obligation does not constitute consideration. Thus, the fact that A owes B a moral obligation does not constitute consideration moving from B to A in order to entitle B to enforce a promise made by A towards discharging the moral obligation. Now, the attempt to equate moral obligation with consideration was made by Lord Mansfield after he became Chief Justice in 1756. However, after his death, this notion came under increasing attack and was finally demolished in the 1840 case of Eastwood versus Kenyon, which is something that you should always have in your head. This authority of Eastwood versus Kenyon, very important. Now, Eastwood, who was a guardian to Mrs. Kenyon whilst she was an infant, has spent a considerable amount of his own money in improving her estate and in bringing her up. When she reached maturity, she promised to reimburse him for his expenses. Her husband also promised to do so independently. When they failed to carry out their promises, he sued them. The plaintiff relied on the defendant's moral obligation to him to enforce their promise. The suit was dismissed and moral obligation was rejected as a basis for an action. Such a notion, if accepted, would destroy the requirement of consideration. The law required an additional factor to the defendant's promise. The factor was consideration and not mere moral obligation, which was inherent already in every promise. Now, this is a very sweet case. Now, let us look at what happened here. So we have Eastwood, right? And then we have Kenyon. Now, Eastwood was the guardian to Kenyon when she was small. And then, when her parents died, they left an estate. Eastwood used his own money to, replenish the estate where the estate was wearing out, deteriorating and all that, to make sure that the estate was in proper condition. Now, the estate here could be like land and all that, properties, which will eventually belong to Kenyon. Do you understand that? Now, when Kenyon now grew, Kenyon now made a promise that don't worry, I am going to reimburse you for everything that you have done when I was young. That's number one. But not just that. Even the husband, so let's say HK, even Kenyon's husband said, Eastwood, you have done well. You are a very good guardian. I would make sure as well that I reimburse you. So we have two promises. One from Kenyon, one from Kenyon's husband, going to Eastwood. Now, the next question is, yes, there is offer, I'm going to reimburse you. There is acceptance. Yes, I accept that you will reimburse me. But then, there is no consideration moving from Eastwood to Kenyon. If there is to be a consideration at all, that consideration will be passed. And don't forget that past consideration is not valid consideration. I will still make sure that I make videos on that, on past consideration and the rules guiding it. But at this point, know that the consideration is past. And as at the time the consideration of replenishing Kenyon's estate was done, there was no contemplation that Kenyon was going to pay her back. So therefore, you cannot say that there was an anticipated contract. No. What we have is that she was replenishing the estate. But after that, Kenyon said, okay, that's like years after, 10 years, 20 years, when she became mature. Kenyon said, okay, don't worry, I'm going to give you. Now, therefore, Kenyon has made a promise, right? For this promise to be binding, and for that promise to amount to a contract, there must be something coming from Eastwood to Kenyon. And there is nothing. And then Eastwood now argued in court that yes, my lord, although there is nothing that seems to be coming from me to Kenyon, however, there is something called moral obligation. And moral obligation has been stated by Lord Mansfield in 1756. Therefore, my lord, there is a moral obligation inherent. Moral obligation means that when I have promised you something, I have a moral obligation to fulfill that promise. So therefore, when she promised me, there is definitely a moral obligation to fulfill the promise. And therefore, the court should enforce the promise. And then the court said, my dear, no, this is not how contract works. No. We are not going to enforce that. I'm sorry about that. We are not enforcing it because the moment we do, we break the shackles of consideration that makes a binding contract. The moment we say that anybody that makes a promise without the other party reciprocating something in return would be valid consideration, then, we are in trouble. You know how many times I can be happy and just say, don't worry, I will buy this for you. I will do this for... we should do that. A lot of cases will get to court. So the court said that when you are talking about a promise to do something, there must also be something coming from this. And the moral obligation inherent in the promise that Kenyon has given to Eastwood, that I'm going to do something. When you say you are going to do something, you have a moral obligation to do it. The court is saying that the moral obligation is not enough to amount to a valid consideration from you. Do you understand that? He is arguing that since there have been a promise coming from Kenyon to Eastwood, that therefore that promise has given him a moral obligation. That means Kenyon, a moral obligation to fulfill that promise, and that is the consideration that he is going to, and that the court said, no, this is your argument, go well. So yes, however, there is a turnaround in another case where the court held that moral obligation and all that would amount to valid consideration. Let us look at what case that is. That is the case of Barclays Bank versus D.C.O. SULAIMON. Now, in an isolated decision of Aguda, as it then was, at the Western State High Court in 1970, in which the learned judge held that natural love and affection between an uncle and his nephew was sufficient consideration to give the nephew good title to the property transferred by the uncle to the nephew without any consideration on the part of the nephew. Now, the nephew's interest was therefore held strong enough to defeat the claim of the plaintiff, a judgment creditor of the uncle, who, having recovered judgment against the uncle, put the property of the latter for sale in execution of the judgment. Now, what happened here is that Aguda is telling us that yes, a property has been given from the uncle to the nephew. And then that property, although there is no consideration from the nephew back to the uncle, but love and affection that the uncle has for the nephew will suffice as a valid consideration, which is still the same as moral obligation. So in the case of Eastwood and Kenyon, Kenyon had a moral obligation, and then the court said yes, although there is a moral obligation, that will not suffice as a valid consideration. In this case of Barclays Bank versus D.C.O. SULAIMON, the court here is saying that yes, there is nothing moving from the nephew to the uncle. What you have is something moving from the uncle to the nephew, and that is the land. And because the uncle loves the nephew, the love and affection that the uncle has for the nephew and which the nephew has for the uncle would then be valid consideration for the gift which has been given to him. And in my head, I'm like, Aguda, no be so they do contracts. I don't understand how you give this kind of judgment, but this is a very, very wrong judgment. And then the court's view that natural love and affection could be equated to consideration is of course invalid in the light of the development of contract law since 1840 and when Eastwood versus Kenyon was decided. So when you are writing your contract law exam, if there is an issue in a problem question and then you are supposed to raise this issue on moral obligation not sufficing as a valid consideration, you must start with Eastwood and Kenyon, where you illustrate that the rule as given by Lord Mansfield in 1756 is no longer applicable in the light of Eastwood versus Kenyon, although a judge, Aguda J, in the case of Barclays Bank versus D.C.O. SULAIMON, had held erroneously, had held par incuriam, that natural love and affection, which is still the same as the moral obligation, will be equated to a valid consideration. That is an erroneous judgment. You must point out Eastwood and Kenyon and this case, and then finally you must also point out the Nigerian case of FALOUGHI versus FALOUGHI. Now in this case, in which a dying father executed an instrument transferring his shares in Excelsior Hotel Limited to his second son. After the father's death, this transfer was challenged by some of the other surviving children. They successfully convinced the court that if it was a gift, then it was an imperfect gift because the father, a foreigner, had not obtained the consent and approval of the Securities and Exchange Commission to the transaction as required by law. The court then considered whether the father's estate was bound to execute the transfer on the basis of the love and affection which the late father had for his son. The court, per Calgo, Justice of the Court of Appeal, held that natural love and affection was not a real consideration and it was incapable of estimation in terms of value. The learned justice stated, and I quote, "Love and affection cannot be quantified in terms of money value, and since it has no value in the eye of the law, there is no consideration." I want this to always ring at the back of your head. Love and affection cannot be quantified in terms of money value, and since it has no value in the eye of the law, there is no consideration. If there is no consideration, then there can be no valid contract to transfer shares by the late FALOUGHI. So here, what are we saying here? We are talking about a very quintessential transfer. The father, when he was alive. Now, I know that you are contract law students and you have not done shares. That you have not done company law. But in a company, if you want to buy a part of a company, you buy what is known as shares in a company. The father bought shares of Excelsior Hotel Limited and then gave those shares to one of his sons. And then when he died, the other children because obviously the shares, they are going to be like a lot of money. If it's 10,000, 20,000, they really wouldn't care. So for example, in current day and time, we have one of the best selling shares, Tesla Motors. If you follow, Elon Musk, who is currently the richest man in the world, or you follow Amazon and Jeff Bezos as well, you will know that if you want to buy at least one share from Tesla in this day and time, I think it costs about $500 for just one share. $500 is going to be about 300,000 naira thereabout. Now imagine that your father bought about 10,000 shares of Tesla. You know how much 10,000 shares of Tesla is? Now then he now bequeathed that particular 10,000 shares of Tesla to you. The other children will fight till their dying breaths to make sure that they get those shares from you. Now, when he bequeathed the shares to the son, the other children fought and said, "My lord, no, these shares cannot be enforceable. My lord, we have to do something." And then my lord said, "Well, what should we do?" And then they argued. "My lord, first of all, this cannot be a gift, because this is in law of equity and all that. I don't want to go deep into it, but when you are going to give a gift to somebody, you must follow the provisions of the law. And because the father was a foreigner, he had not followed a particular provision of the law, therefore it cannot be a gift. However, it can be a contract. Do you understand? It cannot be a gift. The father couldn't have given the shares. The Securities and Exchange Commission is the commission that deals with how you transfer shares in a company, and they have laid down requirements for gift of shares. The father have not followed the requirement of gift of shares in accordance with the Security and Exchange Commission, and in the event where the father doesn't do that, the gift will fail. Now the gift failed. However, that is gifts under shares. Now they want to do contracts. Is there offer? Yes. Is there acceptance? Yes. But still, is there consideration? Now, there is consideration going from the father to the nephew. But my lord, this is very, very important. Quite essential when we are trying to look at a valid consideration, my lord. Therefore, let us look at whether or not there has been a valid consideration coming from the nephew to the uncle. And then my lord looked at it and said, the nephew too was arguing. "My lord, yes, according to Barclays Bank versus D.C.O. SULAIMON, Aguda J stated that love and affection can be consideration, my lord. My lord, in the event of love and affection, which can be clearly seen in this case, that the uncle loved his son so much that he decided to give him the shares. And as well, the nephew also loved his uncle so much that, when they were alive, he did this for him, he did that for him." And then my lord said, I don't think this your argument is correct. Why? Because in as much as you have brought an authority, that is the case of Barclays Bank versus D.C.O, and it is also the opinion of this court that authority that you have brought gave it authority per incuria. Because according to me, which is Cargo JCA, who is currently talking, love and affection cannot be quantified in terms of money value, and since it has no value in the eye of the law, there is no consideration. Like I said, this statement must be in your head. Love and affection cannot be quantified in terms of money value, and since it has no value in the eye of the law, there can be no consideration. Now, based on that, it is obvious that therefore the gift failed because it did not meet the requirement as stated by the Securities and Exchange Commission, and also the contract part of it failed because there was no valid consideration coming from the nephew to the uncle, and therefore the nephew could not get the shares that the uncle has given to him. Do you understand that? Now with this, we are done with our rule in relation to contract and moral obligation. In my next class, I will be dealing with other parts of consideration, where to succeed and where to fail. Do not forget to click the subscribe button as well as the notification bell as well as the like button, so that anytime I release other consideration law videos, you'll be one of the first set of people to watch it. And lastly, also, do not forget to follow me on LinkedIn. I will see you in my next class. Have a beautiful day.